possible under the law. Initially, notice was issued on 2nd of July 2019, fixing the matter on 6th of August 2019. After receipt of the notice on 6th of August 2019, the office was directed to take fresh steps. Thereafter, the matter came before another tribunal from 6th Borpeta to 4th Borpeta. So this time on 8th of June 20, notice was issued fixing 26/08/2020. Notice was served. The proceeding appeared along with his advocate. Took time to file his written statement, prayer allowed. Next date was 23rd of March 2020. 23rd of March 2020, OP remained absent. Date given 22nd of October 2020. 22nd of October, OP remained absent. Counsel for the petitioner filed a petition. It was allowed. Fixed the matter on 21st of November 2020. On 21st of November 2020, again the OP remained absent. Petition filed by the counsel. It was allowed. Fixed on 22nd of December 2020. On 22nd of December 2020, OP remained absent. Petition filed by the counsel. Another date was fixed. That was 12th of January 2021. This time OP remained present along with his counsel. Filed another petition for filing his written statement on 12th January. It was accordingly fixed on 3rd of January, 3rd of February. On 3rd of February 2021, the petitioner remained absent. Counsel filed another petition fixing the matter on another date for filing of written statement. The tribunal considered that since 26th of August 2020, matter is delayed like this by filing petition after petition for filing written statement. But the tribunal considered it and fixed it on 28th of February 2021. OP remained absent without taking any steps. It was fixed on 11th February 21. Again on 11th, the OP remained absent without taking any steps. So it was fixed on 7th of April 2021. On 7th of April 2021, OP remained absent without taking any steps. It was fixed on 17th of May 2021. It was 17th May could not take place because something. It was on 16th of June 2021. Because of lockdown, the case was deferred. Fixed on 20th of July 2021. Then it was fixed on 7th of August 21. On 7th of August 2021, the petitioner appeared again. The petitioner did not appear, but because of COVID, the matter was deferred to 2nd of September 21. On 2nd of September 21, both the petitioner counsel both absent. The tribunal fixed the matter of 1st of October 2021. On 1st of October 2021, the OP remained absent without any steps. And the tribunal found that everything is working in full scale after the COVID period is over. But the petitioner did not appear. However, considering the time, it was again fixed on 9th of November 21. On 9th of November 21, OP remained absent without any steps. Then it was fixed on 9th of November 21, but the matter came up before the tribunal on 9/4/21. then the OP remain absent. Thereafter, from 9th of April 21, it should be 22. It will be 22, something is wrong.
21.
9th of December 21, it should be, not of 9th of April. 9th of April 21, the court granted time to the proceeding up to 4th of January 2022. On 4th of January 2022, ultimately, the ex parte order was passed. Now, in these circumstances, as a court officer,
Okay, fill other.
kindly tell us what the tribunal should do.
Lordship, the date from my lord in entire 2000, my lord. 23 notice served on
Entire 2000, we can understand. In between, the proceeding appeared along with his counsel, he filed his petition. It is
my
not
lord,
that during that period he did not appear, but
Because-
even after the court resumed,
entire 2000 was my lord under lockdown, my lord. From
after 2000, when the tribunal started activities, all the activities started, he did not appear. Yeah, ultimately, the final order was passed on 4th of January 2022,
22, my lord.
and you have filed this petition on 24th of January 2024.
Hmm?
It is not that the proceeding was not aware of the proceeding pending against him. He was aware. But who cares?
No, my lord,
Right.
the situation at that time, my
Situation
lord,
was over. Even
No,
you
well,
as a counsel, definitely, Mr. Ali,
court normally
Ali,
resume, my lord. Lordship.
during the COVID period, the court worked, right? But whoever was not absent, nobody, not a single court dismissed any cases. But the court resumed its work full-fledgedly. Notice was given. Everything was going on from February 2021. It is not that the tribunal did not consider the case during the COVID period or thereafter. And see the audacity of the proceeding. The matter, he was fully aware the matter was pending. He did not file any written statement after taking time till December, January 21. You should have taken steps,
Lordship.
right?
The conduct is not good, my lord. I am admitting.
Then you can,
Conduct is not good.
we are not
So,
concerned.
as my lord, the citizenship right, your lordship knows, my
That
lord.
is, it is
So-
up to him. Whoever sleeps
So,
over his rights,
one
Mr.
opportunity
Ali,
may kindly be
try
given.
in other case.
Because one opportunity,
Sufficient and approved. Dismissed. Next. We are considering enough for other cases you have seen, Mr. Ali, or your counsels you can ask. We always consider, but these kind of things cannot be considered.
May please your lordship. Contested case lordship. Impugn opinion is at page 67.
Let's take your seat. Okay. Hmm. Hmm. Okay. You- No. Heard MS F Intas, right? Counsel for the petition. Also heard Mr. Z Sharma, standing counsel, Home Department, Assam, for the respondent number 2, 3, 2 and 3. Also heard Mr. P. Sharma. H. Kuli, correct. In a reference being made by the Superintendent of Police Order, Golpara. The Learned Furnace Tribunal Court, Golpara, Assam, in FT case number FT within bracket Z-4, bracket close 452 of 2016. After hearing the purpose and considering the evidence adduced by her by the impugn opinion dated 28/02/2023, find the petitioner to be a foreigner under the Foreigners Act 1946, were illegally entered in territory of India. Illegal. Territory of India will make it Assam illegal on or after 25/03/1971. Dissatisfied with the same. File a statement. Call for the record. Before we proceed further, we like to examine the records of. Call for the record. Place this matter for motion immediately.
Interim prayer may be considered loud.
The interim prayer of the petitioner shall be considered in perusal of the relevant.
Observe.
Yes.
Here I challenge two orders of the tribunal and the cross part done by the tribunal. in absence of the learned deputy. Entire clause was conducted by the learned tribunal.
Where is your written statement?
Written statement, I have not annexed.
You have not annexed?
No.
What other different?
I have
Hmm?
submitted written statement, thereafter submitted evidence on affidavit of 3 witnesses.
Where
And
is your written statement? Did you annex?
no, madam,
Why? Why you have chosen to annex only the evidence in affidavit?
because there was no dispute regarding the evidence which I have submitted, written statement submitted by me.
Yes? What is the reason for not submitting that?
My lord, I will submit. I will be allowed to submit.
You have not obtained certified copy.
My lord. Certificate copy. With that. I have obtained the certificate copy of the cross. That is it's 60 and fifty-eight. Then 58 to 71. Then 70.
You are challenging which order?
Two orders, Your Honor.
Yes.
My lord. Order dated 25/1/24 and 28/3/24, whereby the evidence of the mother of the proceeding was declined, and one report was submitted issued by the uh, relief eligibility certificate regarding the relief eligibility certificate issued by the sub-divisional officer Basirhat North 24 Pragna. In the report, it was not clear as to whether they have maintained the record or not in respect of the
It is
particular
whose
area.
case?
In-
Whose case?
This is
You
my,
do you want to rely upon particular document? The
My-
office clearly said it is not there in your favor.
no, my lord, as per
It is
my
up to you
information,
to
they have
prove.
no any record maintained with them.
Not
And
satisfactory.
regarding that Dusty service, I have also,
It is your case, you should have it. Your entire case is that your grandfather obtained relief rehabilitation certificate from the concerned authority at West Bengal.
I have submitted the original with the tribunal. And I have sought a report from the issuing authority.
They have said it is not there.
They have said that it is not in my father's name. Whether there is any record in respect of that particular area, particular
Why do you want to
time.
delay the proceeding in that manner?
That's why I have filed an application to
That
call for the report whether there is any such a.
That is not required.
And I have made this justice service that was refused. And from when I have went to give the justice service on that day, I came to know that they have not maintained the record. That's why I have filed this application.
Tuesday or Wednesday, give your written statement. Like to see your written statement.
Mas-
Petitioner on. They go. List on. 30th. And on the date. Petitioner shall adduce copy of the certified copy of the written statement.
may I file by way of affidavit or directly?
Filed by him. Shall by certified. Filed by him before the Foreigners Tribunal. Number 1 Kamrup Metro at Guwahati in FT case number 456 of 2014.
Lordship, the impugned order starts from page 68. Your Lordship.
Mr. Hussain, take your seat.
Lordship.
Yes, where is your link document?
Your Lordship, my mother appeared before the tribunal and deposed, Your Lordship, that I am her daughter, Your Lordship.
Just tell us if it is without any contemporaneous documents, can it be considered?
Your Lordship, my evidence is relevant as per section 50 of the Evidence Act, Your Lordship. Your Lordship, Your Lordship, since I was born in the year 1979, I have produced the voter list of 1977, where my father's and my mother's name appeared. So I was born as per even by the version of my mother that during the wedlock of my father and mother. So as per section 112, Your Lordship, my paternity established. Your Lordship, the same law has been, Your Lordship, laid down in Karim Ali and Suzab Ali, Your Lordship. My case is covered squarely by Karim Ali, Your Lordship. And Your Lordship, the same thing, Your Lordship, regarding section 50 and its relevance has been discussed by the Honorable Supreme Court in Dole Govinda Parisa, Your Lordship.
We'll come back to you.
Lordship.
Just. Your link document,
Lordship.
procedural link document.
Your Lordship, documents wise, Your Lordship, I have annexed my school certificate, Your Lordship.
Has it been proved?
Your Lordship, it was not proved, Your Lordship.
Then what is the other document?
Your Lordship, other documents, Your Lordship, regarding, Your Lordship, whether I am the daughter of Abdul Mia and Anwara Begum, Your Lordship, there is no document that exists. Your Lordship, the other document that could have been existed, Your Lordship, is the birth certificate, Your Lordship. Your Lordship, the Registration of Birth and Death Act was enacted in the year 1969, Your Lordship. It came into force only in Assam on 1/4/1977, and it became compulsory in the year 1993 only. And Your Lordship, even that, Your Lordship, in the year 2000 and 2001, Your Lordship, during the Service service, and Your Lordship, because there were low turnout of children, Your Lordship, many children were given admission without birth certificate. So even in the year 2000, 2001, Your Lordship, there were many newborns, Your Lordship, who didn't have birth certificate. I got married before the age of 18. Even if I have been in my parents' home, Your Lordship, my name would have appeared along with my mother's name as like my brother's, Your Lordship, whose name appeared along with my mother. Now my mother appeared before the tribunal and deposed that I am her daughter, Your Lordship. And Your Lordship, the only thing, Your Lordship, I have no other documents. Just because I attended school, Your Lordship, I produced the school certificate. And in spite of my, Your Lordship, I have tried to that the principal appear before the tribunal, but he didn't appear, Your Lordship.
Now, did you rely upon any other document?
There is no other document, Your Lordship. And Your Lordship, Section 59 of the Evidence Act, Your Lordship.
Is it applicable?
Lordship, Section 59, Your Lordship.
What is about section 9 of the Foreigners Act?
Your Lordship, Section 9 of the Foreigners Act says that the burden of proof is upon me to prove my citizenship. Your Lordship, it doesn't mean, Your Lordship, it doesn't mean that the Lordship, I will prove my documents with some other law. The documents has to be produced and proved in accordance with the Evidence Act, Your Lordship. And Your Lordship, Section 9 may be read along with Section 106, Your Lordship, of the Evidence Act. Section 106 also says that, Your Lordship, whatever is within my knowledge, I will have to prove. Since my citizenship is within my knowledge, Your Lordship, I'll have to prove it, Your Lordship. And Your Lordship, Section 59 says, only all facts except documents or electronic record may be proved by oral evidence. If there is anything regarding documents or electronic record, Your Lordship, that proves my citizenship, Your Lordship, then I could have proved it. Regarding the birth, regarding my paternity, Your Lordship, I don't have any document or electronic.
So you want to say that even there are no documents, if
Lordship.
somebody claims to be mother and approves before the tribunal, that will be sufficient.
Yes, Your Lordship, for that, Your Lordship, I will produce before this court, Your Lordship, Honorable Court, Your Lordship,
So without any documents, contemporaneous document, the statement of the projected mother or alleged mother will be sufficient, according to you.
No, sir, this is not according to me, Your Lordship. It is according to the law laid by this Honorable Court, Your Lordship.
Just give us the citation.
Lordship. Karim Ali, Your Lordship, 2022, 3 GLT 816.
2022,
3 GLT 816.
81.
May I forward it, Your Lordship?
Just we have. Give us.
Lordship.
Not a fatai.
Are we passing?
What is that, correct? We have to put that in the camera. That was the thing.
In this case also, your lordship, the mother of the petitioner appeared before the tribunal and before your lordship. And your lordship, the relevant portion, your lordship, if your lordship may move on to page 50, para 51 and 52, your lordship. Dol Govinda Parishad. Dol Govinda Parishad.
Which para you are relying on?
Your Lordship, I will rely from paras 46, Your Lordship.
Hmm.
In this regard, Your Lordship,
Hmm.
Your Lordship got it. In this regard, it may be noted that the standard of proof on the basis of which a proceeding is required to discharge its burden under Section 9 of Foreigners Act 1946 is preponderance of probability and not proof beyond reasonable doubt. In other words, if the proceeding is able to show the high degree of probability of being a citizen and this country based on credible evidence, it can be said that he has discharged his burden. The law nowhere requires that a person has to discharge his burden on the basis of proof beyond reasonable doubt. Thus, by applying the said principle of preponderance of probability, we can examine as to whether the petitioner has been able to discharge the burden or not. As para 47, as discussed above, the petitioner has filed his written statement mentioning the particulars of his parents as to how his father had stayed in the house of his mother. In the written statement, it has been also clearly mentioned. There's been also clearly mentioned that the petitioner's father was initially born in Palavita and thereafter got married to his mother called Banu Nesa, who is a resident of Kharmuja, and thereafter he was staying in the house of his wife in Kharmuja. The learned tribunal has not disbelieved the plea of the petitioner that his father appeared in the intermediate examination 1968 from Qatar-e-Haram Senior Madrasa based on the documentary evidence. The said documentary evidence of the petitioner's father having appeared in the intermediate examination in 1968 has not been doubted, questioned, nor impeached in any manner. If that is so, the natural consequential effect of such a fact that his father was very much in India in 1968 cannot be doubted. In fact, it establishes the fact that the petitioner's father was very much in India 1968. The absence of the petitioner's father's name in the voter list of 1970 and 75 has been explained by the petitioner and other witnesses by stating that his father, being a religious person and itinerant, was on the move most of the time. And as such, the aforesaid reason for non-inclusion of his name in the voter list cannot be said to be a reasonable explanation. Your Lordship, these are irrelevant. Your Lordship, we may move on to para 51, Your Lordship. The evidence of the petitioner's mother, in our opinion, is highly relevant and significant, who testified from her direct knowledge about she being married to petitioner's father and about shifting to different villages along with her husband, and also the testimony about the children born to her and the particulars of other relatives. Certainly, the evidence of Kodbanu Nesa, the mother of the petitioner, that the petitioner is her son, is a direct evidence. It will be from her direct knowledge as the mother. As the evidence of the petitioner's mother, Kodbanu Nesa, who testified as DW3, was not shaken during the cross-examination, it has to be given the credibility it deserves in the light of other evidences, both oral and documentary. In this regard, one may refer to Section 50 of Evidence Act 1872, which provides that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. Your Lordship, here to Your Lordship, the DW2 has deposed directly from her personal knowledge, Your Lordship. And those evidence has not been checked, not been rebutted by the state authorities, Your Lordship. In the event of being not rebutted, Your Lordship, the evidence adduced by my mother as well as by me remains unseconded. And that law has been laid by this Honorable Court, Your Lordship. In 2013, 1 GLT 941, Abdul Khalik.
2013.
1 GLT 941. Your Lordship. Your Lordship, suppose I would have submitted the birth certificate and the name of my parents was incorporated in that birth certificate. Even then, if someone came forward and testified, Your Lordship, that I am his or her daughter or son, the question then would also have arisen whether the name of that person whose name is incorporated in the birth certificate is the same person who have come before this court to testify, Your Lordship. So the question will arise. Your Lordship, it is evident, your lordship, I may not have proved my case beyond reasonable doubt, but I have proved my case based on the theory of preponderance of probability, your lordship. Your lordship, the state has done nothing to rebut my evidence or to say that they have taken my evidence to the extent that proved that if I am not an Indian, then I am a foreigner, your lordship. And your lordship, the same ratio, your lordship, has been laid down by the Supreme Court regarding the evidence adduced under section 50. So don't give me the question. Don't give me the question. In Dole Govinda Paricha, your lordship.
Citation, please.
Your lordship. Your lordship, 1959 of 2 SCR 814, AIR 1959, SC 914. May I take your lordship to para 6 of this? Para 5, second para, your lordship. Para 5, second para. Second part, your lordship. With regard, the lordship got it. With regard to the other two witnesses relied on by the plaintiff, namely that of PW2, Janardhan Mishra, ages 62, and 3, Susila Mishran, ages 43. Knowledge of relevant facts as to relationship can seldom be attributed to them. Their evidence, though true and otherwise acceptable, must be based upon their having heard the declaration of such members of the family as were their contemporaries, or upon the tradition or reputation as to family descent, handed down from generation to generation and recognized and adopted by the family generally. This may partly, if not wholly, be based upon conduct within the meaning of section 50, such as treating and recognizing the mother of the plaintiff as Loknath's daughter and the plaintiff as his daughter's son. They, just from their respective ages, could not be considered to have direct knowledge of the matter in issue. Scanning their evidence closely, I find they have in no way deposed about such conduct of a member of the family of Loknath, as could be attributed to the knowledge or belief or consciousness of those who had special means of knowledge of the relationship, or that the relationship was recognized and adopted by the family generally. In the circumstances, I entertain some doubt as to the acceptability of their statement in evidence. Your lordship, this is the portion that was being challenged, your lordship. This case related to the, your lordship, the property of an estate owner, your lordship, and her successors, your lordship, whether they were the children of their half sisters or not. So, your lordship, if your lordship move on to page 60, sorry, your lordship, para 6. Your lordship, the next para, your lordship, till I read till in evidence, your lordship. On behalf of the appellant, it has been contended that the testimony of none of the aforesaid three witnesses fell within the purview of section 50 of the Evidence Act, and the High Court was in error in admitting and accepting that evidence or any part thereof, and according to learned counsel for the appellant, the whole of it was hearsay, pure and simple, somewhat being even second or third hand hearsay. Thus, the second question of our consideration is if the testimony of the witness mentioned above or any of them is admissible evidence within the meaning of section 50 of the Evidence Act. Para 6, your lordship. We proceed to consider the second question first. The Evidence Act states that the expression fact in issue means and includes any facts from which either by itself or in connection with other facts the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follow. Evidence meets and included all statements which the court permits or requires to be made before it by witness in relation to matter of fact under inquiry, and to all documents produced for the inspection of the court. It further states that one fact is said to be relevant to another when the one is connected with the other in any one of the way referred to the provision of the Evidence Act relating to the relevancy of facts. Section 5 of the Evidence Act lays down that the evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are declared to be relevant and of no others. It is in the context of these provisions of the Evidence Act that we have to consider section 50, which occurs in chapter 2, headed of the relevancy of facts. Section 50, insofar as it is relevant for our purpose, is in these terms. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. On a plain reading of the section, it is quite clear that it deals with relevancy of a particular fact. It states that in effect that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who has special means of knowledge on the subject of the relationship is a relevant fact. The two illustrations happen to the sections clearly bring out the true scope and effect of the section. It appears to us that essential requirements of the sections are there must be a case where the court has to form an opinion as to the relationship of one person to another. Two, in such a case, the opinion expressed by conduct as to the existence of such relationship is a relevant fact. But the person whose opinion expressed by conduct is relevant must be a person who as a member of the family or otherwise has special means of knowledge on the particular subject of relationship. In other words, the person must fulfill the condition laid down in the later part of the section. If the person fulfills that condition, then what is relevant is his opinion expressed by conduct. Opinion means something more than mere retailing of gossip or of hearsay. It means something more than mere retailing, or it means judgment or belief, that is a belief or a conviction resulting from what one thinks on a particular question. Now, the belief or conviction may manifest itself in conduct of a behavior which indicates the existence of the belief or opinion. What the section say is that such conduct or outward behavior as evidence of the opinion held is relevant and may therefore be proved. We are of the view that the true scope and effect of Section 50 of the Evidence Act has been correctly and succinctly put in the following observation made in Chandulal Agarwala versus Khalilur Rahman. It is only opinion as expressed by conduct which is made relevant. This is how the conduct comes in. The offered items of conduct evidence is the conduct. But what is made admissible in evidence is the option or is the opinion. The opinion as expressed by such conduct. The offered item of evidence does only moves the court to an intermediate decision. Its immediate effect is only to move the court to see if this conduct establishes any opinion of the person whose conduct is in evidence as to the relationship in question. In order to enable the court to infer the opinion, the conduct must be of a tenor which cannot well be supposed to have been willed without the inner existence of the opinion. When the conduct of such a tenor, the court only gets to a relevant piece of evidence, namely the opinion of a person. It still remains for the court to weigh such evidence and come to its own opinion as to the factum probandum as to the relationship in question. We also accept as correct the view that Section 50 does not make evidence of mere general reputation admissible as proof of relationship. Lakshmi Reddy versus Venkat Reddy. It is necessary to state here that how the conduct or external behavior which expresses the opinion of a person coming within the meaning of Section 50 is to be proved is not stated in the section. The section merely says that such opinion is a relevant fact on the subject of relationship of one person to another in a case where the court has to form an opinion as to their relationship. Part 2 of the Evidence Act is head on proof. Chapter 3, therefore, contains a fascicle of section relating to facts which need not be proved. Then there is chapter 4 dealing with oral evidence, and in it, of course, Section 60, which says inter alia. Oral evidence must, in all cases, whatever be direct, that is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by the sense in that manner. If it refers to an opinion or to the ground on what opinion is held, it must be the evidence of the person who holds that opinion on those grounds. If we remember that the offered item of evidence under Section 50 is conduct in the sense explained above, then there is no difficulty in holding that such conduct or outward behavior must be proved in the manner laid down in Section 60. If the conduct relates to something which can be seen, it must be proved by the person who saw it. If it is something which can be heard, then it must be proved by the person who heard it, and so on. The conduct must be of the person who fulfills the essential condition of Section 50, and it must be proved in the manner laid down in the provision relating to proof. It appears to us that portion of Section 60, which provides that the person who holds an opinion must be called to prove his opinion, does not necessarily delimit the scope of Section 50 in the sense that opinion expressed by conduct must be proved only by the person whose conduct expresses the opinion. Conduct as an external perceptible fact may be proved either by the testimony of the person himself, whose opinion is evidence under section 50, or by some other person acquainted with the facts which express such opinion, and as the testimony must relate to external facts which constitute conduct and is given by person personally acquainted with such fact. The testimony is in each case direct within the meaning of section 60. This, in our opinion, is the true interrelation between section 50 and section 60 of the Evidence Act. In Queen Empress versus Subbanarayan, it just said that proof of the opinion as expressed by conduct may be given seems to imply that the person himself is not to be called to state his own opinion, but that when he is dead or cannot be called, his conduct may be proved by others. The section appears to us to afford an exceptional way of proving a relationship, but by no means to prevent any person from stating a fact of which he or she has special means of knowledge. While we agree that section 50 affords an exceptional way of proving a relationship and by no means prevent any person from stating a fact which he or she has special means of knowledge, we do not agree with Since Justice when he says that the section seems to imply that a person whose opinion is a relevant fact cannot be called to state his own opinion as expressed by his conduct, and that his conduct may be proved by others only when he is dead or cannot be called. We do not think that section 50 puts any such limitations. So, Your Lordship, this was a case, Your Lordship, where some third person or fourth person came to the court and said that he is the daughter or he is the sister or the grandchild of that person. So, in this case, Your Lordship, it relates to direct knowledge. The mother comes before the court and says that I was in a relationship with Abdul Dulal and Dulal Mia. My name is enlisted with him. And thereafter, she deposed that the petitioner is her daughter. So here, Your Lordship, the requirement of the section 50 has been fulfilled, Your Lordship. And thereafter, Your Lordship, the paternity has also been proved as per section 112 of the Evidence Act, Your Lordship. And with regard to the requirement of documents or evidence, Your Lordship, already I have submitted before this honorable court, Your Lordship. Documents of evidence can be submitted only when it exists, which relations to the birth. Since there was no birth certificate and the petitioner was married or before her name was enlisted in the voter list in her parental house, Your Lordship, there was no other option rather than oral evidence, Your Lordship. And Your Lordship, more importantly, Your Lordship, the evidence, Your Lordship, the depositions of the mother of the petitioner as well as the petitioner has nowhere been, Your Lordship, challenged by the state authorities, Your Lordship, by the opposite parties. There is nothing in their record, Your Lordship. And Abdul Khalik, Your Lordship, which I have produced before this honorable court, 2013 1 GLT 941, clearly states in the event of the evidence adduced, Your Lordship, if it remains unsecond, if it is not rebutted, Your Lordship, the evidence exists, Your Lordship.
Okay.
And Your Lordship, there are other cases also on this, based on Karim Ali, Your Lordship, Sujab Ali is one of them, Your Lordship, Idris Ali is one of them. So all these cases were based on this, Your Lordship, ratio, and Your Lordship, they were declared Indian in these cases, Your Lordship. And Haider Ali clearly states that, Your Lordship, this case, in matters relating to Foreigners Act, one has to prove his case based on the theory of preponderance of probability and not based on proof beyond reasonable doubt, Your Lordship.
That's right.
And Your Lordship, there is a clear linkage, Your Lordship, that has been maintained with my grandfather, grandmother, and my mother, Your Lordship.
Okay. Yes, Mr. Sharma. So what Mr. Hussain is saying, if there is a direct evidence, somebody coming as a mother and says that he or she is my daughter or son, is sufficient. And according to him, he has relied on these two decisions as well as also about the section 50 of the Evidence Act. Right? Make your submission. Or if you want to go through the record or anything, Mr. Sharma, it's up to you. It's up to you if you want to go to the records. We are hearing it for final.
Lordship, the first date of judgment is 29/10/2020, Lordship.
Hmm.
After that, Lordship, petition was filed on Lordship in the year 2024.
Mr. Sharma, do you want to go to the records?
Lordship.
Up to you. We are saying this is final. We are in hearing.
Yes, Lord.
Up to you.
I may now.
Here is a case where the petitioner did not prove the school certificate
Yes.
as well as the Gaon Panchayat secretary certificate do exhibited before the tribunal. Now everything remains on the voter list.
Yes.
And Mr. Hussain reiterated that it is the direct evidence of the mother. Think over. To leave it to you.
And also the fact, your lordship, my mother appeared before the tribunal
Uh-huh.
with an identity card. Yes, your lordship, that voter ID card may not be an evidence to prove her citizenship. But that identity card is an identity of herself, that Anwar Begum is the Anwar Begum of whose name was enlisted in the voter list of 93 or 1977. That voter ID card, your lordship, because this card we use while voting, we use in the airport, your lordship. The voter ID card, my name was there, my village name was there. And your lordship, this one. I will actually, I will.
Yes, Mr. Sharma, what do you want?
I have to verify the record.
In that case, we will have it on Monday or on Tuesday. We'll have it on 28.
Can it be on 30, you know? 30, you know.
Okay, on 38. 30.
Good.
List on 38 for motion. Mr. G. Sharma. Hard ayusan लिखे.
Right, Your Lordship.
Who is appearing for the respondent?
Yes, Lordship, I am applying.
Respondent. Who is appearing for the respondent? You
Oh,
are for the
Lord.
petitioner.
Yes, Lordship.
Respondent. Who may be here?
Name is showing, Lordship. As Hussein M. Hawk, S.C. Chigdar.
Sajjad Hussain. Are you aware?
No, Lordship.
You are having the records?
Yes, Lordship.
Okay. Sharma. The state is the petitioner herein, represented by Mr. G. Sharma, Standing Counsel, Home Department, Assam. No representation on behalf of the sole respondent proceeding. The name of three councils have been reflected in the cause list. List again on 28 for admission. Buru. No representation on behalf of the petitioner on call. Placed on 29th. To names of 4 councils for the petitioner has been reflected in the court list. আর আগতে লিখে দাও। The note. Since 01/12/2017, the petitioner is an interim bail and interim protection. Interim protection and same here. Six councils. Interim protection, interim bail since 1/12/2017. In the condition. Notice in this case was issued on 20/12/2017. Registry has already received the relevant records from the Foreigners Tribunal 6th Thubri, Bilasapara. Petitioner is interim protection and interim bail since 2012/2017. Petitioner shall appear before the Superintendent of Police Board of Thubri on or before 19th of June for capturing her condition.
I'm helpless.
In the morning you mentioned, right? Or Mr. V. K. Burwa, Land Council appearing for the petition. Notice in this case was issued on 22/12/2017. Registry already received the relevant records from the Foreigners Tribunal number 1, Morino. Petitioner is in interim protection and interim bail since 22/12/2017. I go to लिखिए hearing बोली था rule लिखा है rule hearing petitioner shall appear before to it. Rule correct. On a date to be fixed by date. Relevant records with it. Morigaon. Actually, notice receipt from Foreigners Tribunal number 1, interim protection interim rate. To appear before Superintendent of Police Board of Morigaon on or before same date for protection for capturing his.
Highly obliged, Lordship.
My pleasure, Lordship. I'm appearing behalf of DK Das, Lordship. He is suffering from illness today.
Notice in this case was issued on 22/12/2017. The registry already received the relevant records from Foreigners Tribunal number 3, Morigaon. Interim protection interim bill 22/12/2017. Appear before Superintendent of Police Board Morigaon. Same date. Baki rule fill the 19th of Ditatu, 19th of June for capturing his biometrics bucket in private. Ask him to appear before the Superintendent of Police Board. Yes, Mr. Kalita.
Fixed on 4th of June, my lord.
I thought we had made a mention before this court for listing of this because my lord, as per the last order of 2/5/24, second para on the pair of MS U Sharma learned government advocate, he is allowed to peruse the relevant medical records and file and accordingly file a detailed affidavit, my lord. However, due to our file being incomplete, my lord, we have to take a copy from the court record. Some relevant medical records as well as police reports are there.
Okay, we'll allow the registry to furnish you a photocopy of the certificate. You just mark out which particular document you need.
Mark.
Go to the records and tell us.
Yeah.
And then you file your affidavit on or before. Twenty-first, we will have it on 25th,
Fine.
right? But mark out the document, show it to him. We'll pass the order. Mr. Kolita.
Yes, sir. Obliged.
Whereas with your lordship, later with the passport for the day lordship. And case counsel Digos is suffering from conjunctivitis.
Just a
and
minute. When do you want?
after 4 weeks,
Why?
he is suffering from throat infection also. lordship.
What's your good name?
A Hussein,
Miss such and such counsel appearing for the petitioner. Learned counsel on behalf of MSD Ghosh. Learned counsel for the petitioner. Submitted the bar that Ms. Ghosh is suffering from medical ailment and a suspect for adjournment of the matter for 4 weeks. To which the learned counsels for the respondents put her name. নামটা লেখা দাও। You are appearing for Mr. Talukdar and MSPV Hanu, right? Not counsel for the respondent number 3 have no objection. They are allowed. List on 25th of June. I don't know. How much time will take?
My lord, what is it? Half an hour.
Okay. Just a minute. Yes, please.
My lord, my first point is, my lord, the Rohizuddin Sheikh, who was the deceased husband of the petitioner, he was arrested on, my lord, 23/5/2018. My lord, in
Just a
connection.
minute. Just a minute. Yes, arrested on
Arrested on, my lord, 23/5/2018, and he was forwarded to judicial custody on 24/5/2018.
then
Then, my lord, he was expired on 1/7/2018 in jail, my lord.
1/7
1/7/2018
in jail.
in jail, my lord.
GMC.
In the hospital, my lord, under the police custody, judicial custody. When he was, my lord, in jail.
Okay, that is enough.
My lord, first
What are the
point,
ground for,
first point, my lord,
no, you are asking
the
for compensation.
cause of death was shown. My lord.
You are asking for
he-
compensation, right?
Yes,
That is the only prayer,
yes, my lord.
right? So what is the reason for asking compensation?
My lord, he was, first of all, he was expired under the judicial custody, my lord, under the police custody. And my lord, my lord, after 2 months, my lord, not 2 months, my lord,
Hmm.
after a month, my lord, he expired in the police custody. My lord, he was admitted in
Your
the
only claim
GMC.
is that as he was in police custody and expired during his custody,
Yes.
so you are supposed to pay the compensation.
Some compensation. My lord, in Lilavati, my lord, in that case, my lord, the
You are relying on Lilavati,
Lilavati, my lord, para 31 and 35,
para 31 and
35.
give us the citation.
I think. Yes. And my lord, in the similar situation, my lord, this honorable court was pleased to pass an order, my lord.
Okay.
In another case,
We'll
he
get
was
back to-
also expired in police custody,
Hmm.
a similar nature, my lord. And my cause of death was, my lord, pneumonia, my lord.
Hmm.
And the medical assistance, what was, my lord, provided to the deceased, my lord, that was,
Okay.
I think, not
What is
sufficient.
the
my
second case?
And he was 65 years old, my lord.
Who
He
was the
has to-
second case?
My lord.
You
that
said
case.
that our High Court has in
Yes,
similar
yes, ma'am.
circumstances passed.
Yes, ma'am. My lord, it was passed.
Give us the citation.
No, my lord, it was not reported.
Okay, okay. Give us the case number.
Case number, yeah. WTC 3363 of 2017, my lord.
3363
63 of 2017.
decided on
Decided on, my lord, 23/3/2023 by the Honorable Justice A.M. Buzarpurwa and
okay, that will do. It's a court.
yes, my lord.
That is the reasons why you are asking for.
Yeah, some compensation. Some
Now just tell us one thing.
financial assistance. Because the petitioner, my lord, he is the widow, my lord, only there is no any other member to take care of her. my lord.
Now just tell us one thing. No children, nothing.
No, my lord. Children.
Okay.
She has, my lord, children, but they are living separately.
What is your ground for filing this petition on 11th of January 2021 when her husband expired on 1st of July 2018 after 3 years?
My lord, the delay, my lord. She is a, my lord, illiterate lady, my lord. Has no knowledge, my lord, regarding the limitation. My lord, somebody said to her that you may file a case, then he came, my lord.
Some wise man
Totally
might have
unaware.
told her. Some wise man might have told her. Haikotত
Maybe.
কেছ কৰিলে পইচা পাবি, কেছটো কৰ।
Yes, my lord, like that. And came and we proceed this case, my lord.
Okay.
And delay part, my lord, perhaps. And my lord, death certificate was collected, my lord, 11/1/2019. And my lord, after death, my lord, one of the relative, my lord, the petitioner's relative, she intimated the incident with the subdivisional officer, judicial magistrate, my lord, Vilasipara, my lord, by filing a FIR, my lord, complaint. In my red petition, page 41.
Okay.
My
This
lord,
is your case.
we are actually, my lord, we are not on the merit of the case, my lord. In some assistance, my lord, financial assistance to her, my lord.
Yes, Mr.
There
Naksh.
is many scheme, my lord, under the government. Little bit, my lord.
What is the first date when he suffered ailment?
Well, he was treated, he was given treatment in the jail.
Hmm.
After his he was put in the jail, my lord. In the
See,
month of, in the month
First
of,
treatment jail.
yes, my lord. For hypertension, he was given treatment. He was sent to jail on 25/5/2018, my lord. 25, 5th of May,
Now,
2018.
what we have seen on last date is the first, though he was given treatment and he was referred to Dhubri Hospital.
Lordship,
From Dhubri
hypertension,
Hospital, he was referred to Guwahati Medical College.
Guwahati
Hospital
Medical
or,
College.
Kokudina Rehmed Hospital, Borpeta.
Lordship. Well, after his arrest,
Hmm.
and he was sent to judicial custody on 25th of May 2018, he was given treatment for hypertension in district jail. And that treatment continued till the next month. And when his condition deteriorated, he was admitted to, first he was referred to Dhubri Civil Hospital. Then the doctor of Dhubri Civil Hospital, they referred him to the GMCH.
Now, when he was admitted in the GMCH,
GMCH, he was admitted on 30/6/2018.
okay. Then,
Then, my lord, on 1st of July, on the next day at around 2 p.m., he expired. My lord, after his expiry, the postmortem was conducted. Inquest report was, my lord, prepared. There is no bodily injury, nothing, my lord. And the postmortem report as well as the forensic report, it suggests that the death was due to pneumonia and it was natural, my lord. It was natural death.
okay.
After his death, the Assam Human Rights Commission, that order we have brought on record, my lord, registered a case, my lord, and notice was issued to us. Accordingly, reply was given. In fact, a ministerial inquiry was conducted as per the Assam Human Rights Commission's order. After perusal of that report and along with the others, the commission has closed that, my lord, considering that death was natural.
Where is the order of the last time you have placed before the court somewhere?
My lord, the Assam Human Rights Commission order in the additional affidavit, Lordship will find at page 53, my lord. Order dated 3/4/2019.
That's right.
There, Lordship will find in the second paragraph, the commission has said, after taking cognizance of the case, notice was issued to the district magistrate Kamrup Metro to conduct an inquiry to find out the cause of death of the deceased UTP and submit a report to that effect within 1 month. The inquiry was apparently conducted by additional district magistrate Kamrup Metropolitan District Guwahati, who submitted his report on 2/3/2019, which is now with us. The inquiry officer observed that the UTP was under medication to treat his disease in addition to his hospitalization at the GMCH Guwahati. He was diagnosed with acute chronic destructive pulmonary disease, and that the cause of death was due to the progress of his disease. We have carefully gone through the inquest report, postmortem examination, and medical report of GMCH, as well as the statement of the IO and the statement of the doctor. Doctor statement also taken, my lord. On the basis of those materials, we are satisfied that the findings of the inquiry officer are fully corroborated to the above materials. We have no alternative but to conclude that the deceased UTP died of natural cause, and he is not a victim of violation of human rights. Moreover, no complaint has so far been received from any of the relatives of the deceased UTP. Consequently, the inquiry is closed.
Mr. Nath, please come to page number 68.
68 is their reply, my lord.
This is a report from?
Possibly.
The last page.
In the additional application. Lordship. This is a report of the forensic, the demonstrator forensic medicine, GMC. The opinion is that death was due to pneumonia.
Date was due to pneumonia.
Natural death.
Last line,
My lord,
multiple or what? Multiple section from the
From-
tissue. Also,
tissue shows
tissue show
Pneumonic
fracture of pneumonic
lung.
lungs.
Lung.
Fracture, I don't think so. This is it fracture? FRA. There is no C.
But in the PM report also, there is an indication in the left lung.
into left lung also found to be collect.
But if for a moment, my lord, kindly lordship comes to page 33, that is the postmortem report.
Found to be collect and secure. Next lung.
As regard the right lung, lordship will find right lung, then left lung.
Hmm.
But the
Also is found
also is found to be
collect
collapsed at
and
febrile. Collapsed at
You are reading at page.
page 33. Page 33. Lordship, it's a part of the postmortem report. Lordship will see the first of the column. The second column, right lung, then comes left lung. The remark noted as regard the left lung. my lord. Normally, I'm just indicating that normally in case of pneumonia, this happens, my lord.
No, it is not.
But in the writ petition, postmortem report is there, my lord.
Page 33.
That from there only we're saying page 33 is the report starts, right?
Yes, my lord. The right lung and left lung, lordship has got, my lord.
Page 20,
Page number of Roman 3, just below, my lord, postmortem report, lordship will find Roman 3,
thorax,
thorax. Then below that, my lord, right lung,
right and left lung.
right and left lung. Left lung, there is a remark, also is found to be collapsed at febrile. So this has a connection with that, my lord. Ultimately, in case of pneumonia, the lung failure is a common thing, my lord.
Now, where you will show that you have provided him all medical benefits while he was in custody?
My lord, medical documents are with us, my lord. Medical documents we have received. Kindly, my lord, see the from 25th of May onwards,
Where is it?
lordship. Hmm, hmm. দিলে ma'am, lord. এই কারণ না, page number করা আছে না? Okay, আপনি না, এলাকা তো নিম্ন দেখা যায় না, দেখি। On 25/5/2018, lordship will find at this page number 1 and 2, my lord. At the top left corner, it is written, my lord, page number 1, 2. Medical report, medical report.
Mr. Nath?
Hello.
Telmistan 40, amlodipine 5, pantoprazole 40, cetimetyl MD, given for what? Then on 11th of June, he was provided with injection pantoprazole, the antacid that is related to gas again.
Gas.
Then telmistan and amlodipine relating to hypertension.
Lordship. He was
And,
undergoing treatment for hypertension. Not a DA.
Only pantoprazole 40 is related to gas, right?
Gastric.
Then all medicine was given for only for the purpose of his hypertension and
Hypertension. Yes, my lord. From 25th of May onwards, treatment for hypertension was given at district jail, my lord.
diclomine. Diclomine again injection is for the see one thing, what is the want to know from you, Mr.
Lord.
Pneumonia is not such that it will happen straight away. Not an affair of 1 day or 2 days, right? But his medical report is clear that he was treated only for his hypertension.
Initially, yes, my lord. Since the month of May onwards, he was treated for hypertension. But
And normally what happens? When in similar situation, somebody stays together in custody or chest X-ray is first. Because here we are suffering from mostly TB or lung related issues.
it is
Or blood release, okay, yes, then everything. We are keeping this for a while.
My lord. ECG, X-ray, those were done, matlab, when he was, matlab,
In Dhubri,
yes,
that is why he was referred to Guwahati or Barpeta.
in Dhubri, it was done. When he was first admitted to the jail, it was done.
While he was first admitted in the jail, his X-ray and everything was
Yes,
done.
it was done. It was done.
Where will you show, can you show it from here?
All of that. Yes, I just remember, matlab, I have seen some of that.
Borua. Heard Mr. S. A. Ahmed, counsel appearing for the petitioner, and Mr. D. Natlan, and senior government advocate, Sam. For the respondents, 127.
Thank you.
Hearing concluded. Order is up. Give it to us,
Obliged.
that report.
It needs control of. Well, can I have it? Can I take a copy of the bunch? I'll just take a copy and I'll give. Right now, I'll give.
Note. Mr. Nat, and senior government advocate has also placed all the relevant documents relating to the treatment of the deceased husband of the petitioner. Before the court. Error for technical review. Kapasik po nalego. Itu correct. Into ভাল scan kuri pele photo. Ene photo state nahi ko pare.
Obliged.